Hello dear students, welcome to today's episode. We have covered the importance of labor welfare as well as the necessity of social security measures in part 1. In this episode, we will discuss the efforts and plans made by the Indian government to provide workers with labor and social security benefits in order to protect and secure their interests. I am Dr. Nidhi Mathur, PhD in Public Administration and teaching at Institute of Management Technology, Center for Distance Learning, Ghaziabad. So, let us begin our discussion on the social security system in India. The social security system in India is made up of numerous plans and initiatives that are dispersed throughout numerous laws and rules. But keep in mind that just a small part of Indians are covered by the country's centralized social security system. Additionally, the social security system in India includes not just an insurance payment of premiums into government funds, but also lump sum employer obligations. The following social insurances are generally covered under India's social security programs: pension, health benefits and insurance, disability insurance, parental leave and gratuity. While a large portion of the Indian population works in the unorganized sector and may not be eligible for any of the aforementioned programs, Indian citizens employed in organized sector, including those employed by foreign investors and their employers, are entitled to coverage under the aforementioned programs. Social insurance contributions are required in several situations. Some social insurances demand employers' contribution from all businesses, others from those with 10 or more employees or more, and yet others from those with 20 or more employees. Each of these social insurances will be covered in this episode along with information on their coverage, contribution amounts and the laws and regulations that support them. Let us now discuss about the Social Security Code 2020. The following laws are incorporated into the Code of Social Security 2020. One of the 4 new labor codes announced by the Ministry of Labor and Employment are the Employees Compensation Act 1923, the Employees State Insurance Act 1948, the Employees Provident Fund and Miscellaneous Provisions Act 1952, the Employment Exchanges Act 1959, the Maternity Benefit Act 1961, the Payment of Gratuity Act 1972, the Senior Workers Welfare Fund Act 1981, the Building and Other Construction Workers Welfare Cess Act 1996, and the Unorganized Workers Social Security Act 2008, Employees Provident Fund or Pension. The Ministry of Labor and Employment's Provident Fund organization provides superannuation pension and family pension in the event of a worker's passing while on the job. Out of India's 400 million workers, only roughly 35 million have access to official social security in the form of old age income protection at the moment. Out of these 35 million workers, 26 million are part of Employees Provident Fund organization, which includes those employed in the private sector, the government, the military, and state and local public sector organizations. Businesses with at least 20 employees may use the EPFO's program. When an employee earns up to rupees 15,000 per month, contribution to the Employees Provident Fund scheme are required for both the company and the employee and optional when they earn more. If an employee's pay is higher than this, the employer's contribution is only due for the first rupees 15,000 of that employee's income. The payment rate for both the employee and employer is capped at 10% for establishments with less than 20 employees or those that satisfy other requirements as specified by the EPFO. The Employees Provident Fund organization oversees three schemes. Number 1, the Employees Provident Fund Scheme 1952, the Employees Pension Scheme 1995 and the Employees Deposit Linked Insurance Scheme 1976. The Employees Provident Fund scheme is contributed by the employer 1.67 to 3.67% and the employee 10 to 12%. The employee pension scheme is contributed to by the employer 8.33% and the government 1.16%, but not the employee. Finally, the employee's deposit linked insurance scheme is contributed to by the employer 0.5% only. There are 4 main pensions options available, all paid monthly. Pension upon superannuation or disability, widow's pension for death while in service, children's pension and orphan's pension. Additionally, there are separate pension plans for civil persons, marine persons and those employed in the state of Assam's tea and coal plantations. For each employee covered by the Employees Provident Funds and Miscellaneous Provisions Act 1952, the EPFO assigns a universal account number. The UAN is portable for the duration of an employee's career and is connected to their EPF account. As a result, transferring an EPF account when changing jobs is not necessary. A worker may take either a full or partial withdrawal from their provident fund. When the employee retires or is out of work for more than 2 months, a full withdrawal is an option. In this case, the person must fulfill particular bureaucratic procedures such as having their claims confirmed by a gazetted authority. It is not authorized for an individual to completely withdraw their EPF benefits owing to a job change if they have not been out of work for more than 2 months. In specific situations such as for medical needs, marriage, education, home loan repayment, buying land, building a house, etc., a partial withdrawal of the EPF may be made. This is dependent on a number of established criteria, including the employee's length of service. Health benefits and insurance. The government health services in India does not provide free health care for the entire populace. The Employees State Insurance Act of 1948 established a fund to pay for medical expenses for workers and their families. cash benefits during sickness and pregnancy, and monthly payment in the event of death or disabling conditions for those employed in factories and other establishments with 10 or more employees. As of March 31, 2019, there were about 130 million ESI beneficiaries and over 1 crore 20 lakh factories and commercial buildings were included. Hotels, stores, theatres and restaurants, newsstands and road motor transport operations are now included in ESI scheme's coverage. Private academic and medical institutes with 10 or more employees are now included in the program. Only specific states and union territories are affected by this. In the event of any unlucky circumstances at work, the ESI system provides benefits to both the workers and their dependents. Employees or workers working in the aforementioned categories who earn up to rupees 21,000 per month or rupees 25,000 per month in case of a disabled person are eligible for this social security program under the ESI Act. The ESI is funded by 0.75% of eligible employee salaries and 3.75% from the employer for a combined contribution of 4.5%. From July 1, 2019, these new rates are in effect. These rates were 1.75% and 4.75% earlier, within 15 days of the ESI Act becoming relevant to that entity. The company or establishment may submit an application for an ESI registration. The Employees State Insurance Amendment Rules 2017, which outlines new maternity benefits for women with insurance, were announced on January 20, 2017. 51,20,000 women had benefited from the program as on March 31, 2019. Daily wage laborers who make an average of up to rupees 137 are further excluded from making a donation. However, employers are required to make their own contribution with regard to these employees. For a maximum of 91 days per year, the ESI sickness benefit is payable at a rate of 70% of the average daily earnings. The insured worker must pay into the system for 78 days during the course of a 6-month period in order to be eligible for illness benefits. There are provisions for additional sick days and corresponding qualifications. In addition, ESI offers a temporary disablement benefit that is effective the day after starting an insurable job. Depending on the degree of loss of earning capacity as determined by a medical board, the permanent disability benefit is paid at the rate of 90% of wage in the form of a monthly payment. The ESI also offers benefits for dependents, that is, dependents benefit in addition to payment for illness and disability. When an insured person passes away as a result of an occupational hazard or an injury sustained on the job, a monthly payment equal to 90% of the deceased person's wages is made to the dependents of the deceased insured person. Other benefits that are offered with ESI are medical benefits, maternity benefits, unemployment allowance, confinement expenses, funeral expenses, physical rehabilitation, vocational training and skill upgradation training under Rajiv Gandhi Shramik Kalyan Yojana. Employers that were unable to file the return of ESI contribution for the contribution period from April 1, 2020 to September 30, 2020 due to the extenuating circumstances faced by the businesses in that year, have been granted a one-time indulgence. Employees who contribute to and benefit from the ESI are unaffected by this. Additionally, neither newer nor older contribution periods have received any additional relaxations. Disability insurance. In cases of work-related injuries that end in death or incapacity, the employer is required by the Employees Compensation Act of 1923, formerly known as Workmen's Compensation Act of 1923, to give compensation to the employee or their family. Additionally, those who work in certain occupations run the danger of developing certain illnesses that are peculiar and specific to their job. An employee who contracts an occupational disease is considered to have been injured while on the job, and the employer is responsible for covering related medical expenses. Part 1 and 2 of Schedule 1 of the Employees Compensation Act enumerate injuries that result in permanent, whole and partial disability, while parts A, B and C of the Schedule 3 of the Employees Compensation Act specify occupational disorders. By notification SO 71E issued on January 3, 2020, the central government modified the wage amount to be taken into account for calculating compensation to workers under the Employees Compensation Act 1923. According to the statement from the Ministry of Labour and Employment, it will now cost Rs 15,000. The previous wage that was taken into account while determining compensation was only Rs 8,000. Calculating compensation is based on the circumstances of the occupational disability. Death. 50% of the monthly wage times the pertinent multiplier, or Rs 1,20,000 more, whichever is higher. Complete and permanent disability. Rs 1,20,000 or 60% of the monthly wage multiplied by the pertinent component, whichever is higher. Schedule 4 of the Employees Compensation Act lists the relevant computation factor. Maternity benefit. On April 1, 2017, the Maternity Benefit Act 2017, which increased some of the major benefits required under the previous Maternity Benefit Act of 1961, went into effect. The revised law extends paid maternity leave for the first 2 children to organized sector women for a total of 26 weeks, up from the previous 12 weeks. The third kid is eligible for a 12-week maternity leave. India currently ranks 3rd in the world for the length of maternity leave, behind only Norway, which is 50 weeks, and Canada, which is 44 weeks. The Act also guarantees mothers who adopt children under 3 months of age 12 weeks of maternity leave, as well as commissioning mothers, that is biological mothers who choose surrogacy. In these situations, the 12-week period will be measured from the day the child is given to the adoptive or commissioning mother. In addition, the law requires that every business with more than 50 employees have access to a nearby creche that the mother can use up to 4 times per day. Companies should be aware that this particular regulation is into effect from July 1, 2017 for compliance considerations. In accordance with the Maternity Benefit Act, women now have the option to negotiate work from home arrangements with their employees after their maternity leave has ended. According to the Pre-Existing Maternity Benefit Act of 1961, every woman is entitled to maternity benefits at a rate equal to the average daily income for the time of the employee's real absence from work, and her employer is responsible for paying those benefits. A female employee is also entitled to a medical incentives of rupees 3,500 in addition to 12 weeks of pay. According to the 1961 Act, an employee is entitled to 6 weeks of paid maternity leave in the case of a miscarriage or medically assisted pregnancy termination. In the event of issues related to pregnancy, delivery, premature birth, miscarriage, medical termination, or a tubectomy procedure, employees are also entitled to an additional month of paid leave, 2 weeks in this case. In addition to the aforementioned, the 1961 Act specifies that no corporation shall require its female employees to perform strenuous duties or tasks that require prolonged standing or that in any manner could endanger the health of the employee or interfere with her pregnancy or the development of the fetus. Changes anticipated under the Social Security Code 2020. To make sure the Act's regulations are followed, inspector cum facilitators will be appointed. They will be able to ask employers about their female employees, including the type of work they do, how much they are paid, and whether they have any complaints. Offending employers would be given time by inspector cum facilitator to start adhering to the Act's standards through a written statement. If they do, nothing will be done to stop them. It would be made sure that female workers who are employed in unorganized industries can prove their identity using their Aadhaar numbers. Employers who deny their female workers the right to maternity leave will be subjected to a fine of rupees 50,000, a minimum of 6 months in jail or both. Under the Trade Unions Act of 1926, a female employee who is denied maternity leave may file a complaint with her trade union, which will thereafter be heard in any court having appropriate jurisdiction. However, the only people who can ask the court for assistance are the refused employee and the inspector cum facilitator. Gratuity. According to the Payment of Gratuity Act of 1972, businesses with 10 or more staff members are required to give employees who have been with a company for 5 years or more an additional 15 days of salary for each year of service. A corporation will pay out a lump sum of gratuity. The gratuity must still be given to the employee's nominee or heir in the case of his or her demise or disability. However, if an employee has been fired from their employment for any reason, the employer has the right to refuse to give them a gratuity. In such a forfeiture situation, a termination order detailing the allegations and the employee's wrongdoing is required. The formula for calculating gratuity is gratuity equal last drawn salary multiplied by 15 divided by 26 multiplied by tenure of service, where the ratio 15 by 26 represents 15 days out of 26 working days in a month. Last drawn salary equal basic salary plus dearness allowance. Tenure of service is rounded up or down to the nearest full year. For example, if the employee has a total service of 10 years, 10 months and 25 days, 11 years will be factored into the calculation. Gratuities are tax free as long as they don't exceed 15 days of pay for each year of service that has been completed, computed using the most recent income, subject to a maximum of rupees 2 million. It is crucial to remember that a company has the option to provide an employee a larger gratuity known as ex gratia, which is a voluntarily made payment. Ex gratia is tax deductible. Schemes for workers in the unorganized sector. Atal Pension Yojana. Introduced in the year 2015, this program is aimed towards unorganized workers including nannies, drivers, gardeners, etc. It enables these workers to set money aside for retirement. The Pension Fund Regulatory and Development Authority is in charge of managing it. Social Security Act for Unorganized Workers of 2008. The Act was introduced to offer social security benefits for the welfare of unorganized sector workers. The Ministry of Labour and Employment is responsible for carrying out the Act. The Rashtriya Swasthya Bima Yojana program was introduced to address the unorganized workers' urgent medical needs. It is a form of health insurance program for employees in the unorganized sector. Aam Aadmi Bima Yojana. This government-sponsored social security program was created to safeguard the interest of thousands of people employed in unorganized industry, occupational groups. When an insured person passes away naturally or due to an accident or becomes disabled, etc., the plan pays payments to the insurer. The Contract Labour Regulation and Abolition Act of 1970 aims to safeguard workers from all forms of exploitation at work by establishing better working conditions for them. Food security in India. India has always been quite concerned about its food security. The government periodically implements different policies to address it. This covers the National Food Security Act 2013 as well as the Public Distribution System, Revamped Public Distribution System, Targeted Public Distribution System, Antyodaya Anna Yojana, Annapurna schemes and others. So, in this episode, we have discussed several laws and rules in place to deal with social security in India, but they only apply to a relatively small portion of the population. In order to ensure appropriate program implementation, cooperation among various stakeholders is a must. Establishment of delivery infrastructure, dissemination of awareness and the prevention of corruption. Hope you understand the lecture. We will meet you in the next episode. Till then, thank you and goodbye.